Assalamualaikum warahmatullahi wabarakatuh. We are from Group 5. We will present about enforcement of environmental law through civil law instruments. Before we explain about our topics, the first is I will introduce the member of the groups. The first is me, Iklimah Qurana Nabila. The second is Fatimah Syahra, and the last is Anissa Siti Zahra. The purpose of environmental law enforcement. The first is efforts to solve environmental problems that occur in Indonesia is to guarantee legal certainty in law enforcement the law. The second is enforcement of environmental law is an effort to achieve compliance to the regulation and requirements in the applicable legal provisions in general and individually through supervision and application in administrative, civil, and criminal ways. The third is as a structuring of ecosystem protection, values, and environmental functions. The next is the aspect of civil law in environmental management is one aspect of environmental law enforcement. With the occurrence of environmental pollution and destruction, there will be victims of pollution and destruction in the sense of being the injured party, and the injured party can be an individual, community, or state. In UU PPLH, the process of enforcing environmental law through civil law procedures is regulated in Chapter 13, Article 84 to Article 93. The next is civil instruments in environmental law enforcement are carried out in from the aspect of civil law dispute resolution environment can be done through two paths, namely the first is process outside the court or litigation. The second is and the process path through the courts or non-litigation. The next explanation will be presented by Sister Fatima. Sister Fatima, time is yours.
Okay, and the next is settlement of dispute out of court litigation. Article 85 states that the settlement of dispute outside the court is carried out to reach an agreement on the form and amount of compensation. Recovery action due to pollution or damage regarding certain action to ensure that pollution or destruction will not occur or repeat and to prevent negative impact on the environment. And the next is dispute resolution outside the court. In the resolving dispute outside the court, the service of a neutral third party can be used to help resolve environmental dispute. Dispute resolution in this way is known as alternative dispute resolution ADR. ADR institutions are arbitration, mediation, and negotiation, and conciliation, which are currently widely used by industrial in resolving environmental dispute. In Indonesia, especially in cooperation agreement between investor and the community in the event of environmental pollution. In addition to the explanation of Article 86 state that the government and or the community may form an institution providing service for the settlement of environmental dispute that is free and impartial. Next is settlement of dispute through court non-litigation. Settlement of environmental dispute through the court is regulated in UU PPLH Article 87 to Article 92, Article 87, Paragraph 1 state that every person in charge of a business and or activity commit an act that violate the law in the form of environmental pollution and or destruction that causes harm to people, other or the environment must pay compensation and or take certain action. And the next slide is delivered by Anissa Siti. Nisa, it's time yours.
Okay. Next, I will explain about the GATS compensation compensation. Based on the provision of Article 87, paragraph 1, in order to file an environmental lawsuit, to obtain compensation, the following elements must be met. The first is each person in charge of the business or activity. Next, commits of violation law. The third, in the form of environmental pollution or destruction. The fourth is ensure losses on other people or the environment. And the last, the person in charge of the activity or pays compensation and or takes certain action. Next. Civil code or KUHP perdata. This is also related to civil law as stated in several articles in civil code or KUHP perdata. Below, namely Article 1365 of civil code state that every act that violates the law that causes harm to another person obligates the person who, because of his or her fault, issue the loss compensation for the loss. Article 1366 of the Civil Code states that every person is responsible not only for losses caused by his action, but also for losses caused by negligence or carelessness. Article 1367, paragraph 3 of Civil Code states that the lawsuit based on Article 1365 of Civil Code must meet the following condition. The first is failed or school. Number 2, loose or skate. Number 3, casual relationship or casual forbidden. And then the last, relativity or relative weight. Next slide. Okay. In UU PLH, Article 88 of the UU PLH stipulate that every person whose actions, business, and or activities use B3 procedure and or B3 weights and or process straight to the environment is responsible for absolute responsibility for the losses that occur without the need to prove the element of error. Next. Okay, by the principle of absolute liability, it's mean a principle of accountability with a view that fault is irrelevant to be questioned whether in fact it exists or not. There is also a class action lawsuit mechanism in the context of resolving environmental dispute involving a large number of victims. Class action, or in Indonesian knows as class action lawsuit, is a procedure in civil case that give procedural rights to one or several people or in small number to act as a plaintiff to fight for the interest of the plaintiff who are class representative, who at the same time represent the interest of many people or hundreds of thousands or millions calls members who experience the same suffering or roles. This is regulated in Article 91 as well as in Article 19.2. It is regulated regarding profession and explanation regarding the rights of environmental organization to sue. Next, the last is conclusion. Based on the okay, the last is conclusion. Based on the description above, the civil law aspect in environmental management is one aspect of environmental law enforcement. In UUPLH, the process of enforcing environmental law through civil procedure is regulated in Chapter 13, Article 84 to Article 93. The civil aspect listed in this article contains the settlement of environmental dispute that arbitration, mediation, negotiation, and conciliation or other out of court or non-litigation channels by means of absolute responsibility, class action or class action lawsuit, and environmental organization rights to sue. It can be chosen based on the voluntary choice of the dispute parties. Okay, thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.